My name is William Haun. I'm a non-resident scholar here at the American Enterprise Institute. It's a pleasure to welcome you all to AEI, both here in person and those watching us online. On behalf of both AEI and the CUA Law Center for Law and the Human Person, I'm really looking forward to having this discussion with all of you on Mahmoud versus Taylor and the future of parental religious exercise. It's fitting that AEI and the Center for Law and the Human Person, which is co-sponsoring this event, would want to host a discussion on what is the most significant Supreme Court decision on parental authority in at least a half century. Both AEI and the Center look at American law and desire in a certain way and for their own reasons what our AEI friend Yuval Levin calls a fuller constitutionalism. That is to say, an approach toward the Constitution that is less focused just on a judge's role in interpreting the Constitution, but appreciating the role that all the institutions of American life and within the constitutional architecture create, presume, and need in order to maintain self-government. And among those institutions, of course, is the family. The Supreme Court of the United States has long spoken in lofty terms about parental rights, but the Mahmoud case presented something that was a bit more focused, that is, the authority of parents to direct their children's religious upbringing in relation to the authority of public schools to educate American citizens. In important ways, Mahmoud suggests that the Constitution recognizes parental religious direction as not some kind of permission slip from a baseline of state power that the state has to hand out to parents when it treats them badly, but rather recognizing what Mahmoud says, which is that there is a special character to parental religious direction, their own authority to direct their children's religious upbringing for obligations that transcend the state. Respecting that distinct sphere for parental authority is crucial to our constitutional infrastructure, just as preserving the other ways in which the Constitution presumes or creates separated power spheres, like the separation of powers or federalism. We will explore that crucial commitment to parental religious direction and its constitutional implications through two panel discussions this afternoon. One, the first one, will be focused on Mahmoud itself and its legal implications, and the second will be on its broader cultural significance for the family in preserving American self-government. To have that discussion, I am both honored and grateful to be joined up here with colleagues and leaders in building out the American tradition of respecting the family as a necessary society. The first that we'll hear from is Eric Baxter. Eric is Vice President and Senior Counsel at the Becket Fund for Religious Liberty, and he was lead counsel in Mahmoud versus Taylor, arguing that case at the U.S. Supreme Court. And it was a particular honor for me to get to sit next to him during oral argument and geek out about the fact that we made it to the Supreme Court and look around at the beautiful architecture. We also have up with us here Helen Alvarez, who is the Robert A. Levy Endowed Chair in Law and Liberty at the Antonin Scalia Law School at George Mason University, where she teaches family law and religion and property law. She authored an amicus brief in Mahmoud and was cited twice by Justice Thomas in his concurring opinion, and she is a leader in scholarship on religious exercise in American life, the role of religious institutions, and particularly the Catholic Church in furthering American self-government. We also are joined by Elizabeth Kirk, who is Assistant Professor of Law and Co-Director of the Center for Law and the Human Person at the Columbus School of Law at the Catholic University of America. Her scholarship brings out really important insights and contributions into how the law and the family interrelate. And as an alum of CUA Law, I must say I'm very impressed at all that the center that she and her co-director Mark DiGirolamo are running and all that they're doing to further improve our legal vocabulary in favor of human dignity. So I'm grateful for you being here, Elizabeth, and for the center's co-sponsorship. With that, we're going to begin with some opening remarks from each one of the panelists within the range of 5 to 8 minutes. And then we will have discussion among the panelists, and then I will open it up to the audience, both here and online, with further instructions at that time. If you could please welcome our panelists with a round of applause. So Eric, why don't you go ahead and get started for us?
Yeah, I was asked to give just some of the background of the case to lay the ground for our discussion today. Most of you may already know, but I live here in Montgomery County, just not far from where we are right now. Two of my kids went to Montgomery County Public High Schools. One of the things we loved about the schools is just the diversity. It's been recognized for quite a while as the most religiously diverse county in America. And our kids had great experiences there. There were a couple of incidents where my kids, both boys, came and just on their own said, hey, I'm reading this book. It's making me feel uncomfortable. We asked for opt-outs. They got opt-outs. But one morning in early 2023, my wife was laying in bed with me, and she was reading the news, and she said, I think you've got to sue Montgomery County, Maryland, and the public schools. And what happened, the school had introduced a series of storybooks for children in grades pre-K through 5th grade and beyond, but those were the ones that were mainly of concern, that were introducing issues around sexuality and gender. One of the books was called Pride Puppy, about a puppy who gets lost in the parade and 2 kids who run through the parade and all the things you might learn in the parade. And then a word search list at the end where you're asked to look for things like underwear or zipper or lip ring or drag queen. That was for pre-K through kindergarten. One of the books was about a boy who identified as a girl, and the story was about how this boy persuaded his family that he was a girl, and in ways that, basically deferring to a child's own sense and disregarding parental feelings or thoughts or concerns about those issues. One of the books was about 2 4th grade girls who fall in love, and they exchange valentines, introducing this idea of same-sex romance to young children. One of the startling things about the case is Montgomery County's principals union, which is one of the most liberal counties in the nation, and the union you would expect to kind of follow that. They actually wrote a letter to the board saying that they thought these books were inappropriate for children of that age, that it was unduly dismissive of contrary religious beliefs, that it was dismissive of parents' concerns, that it would create a divide between parents and the schools. But the school plowed forward. They initially allowed opt-outs. As I mentioned, Montgomery County has a history of being very generous on these types of issues. They had a policy that said anything that violated your religious beliefs, you could opt out of. And that continued for most of the 2022-2023 school year. On March 22nd, the school board reiterated that in a public statement to the media that they would respect the opt-outs. The very next day, they issued a new press release on March 23rd saying they would no longer allow opt-outs and would not even notify parents when these books were being read. And their explanation was that every child needs to learn this information. And in addition to the storybooks, there were guidance for teachers that said, if students complain, you can tell them that their contrary opinions are hurtful. If students question whether a man can wear a dress, you say, "Oh, Harry Styles, he wears dresses. Do you not like Harry Styles?" And basically using both teacher pressure, cultural pressure to try to what the school board said was their goal was to disrupt either or thinking on issues of gender and sexuality. There were literally over 1,000 parents showing up at school board meetings protesting the withdrawal of the opt-outs. And in response, one of the school board members compared the parents to racists and xenophobes. Mind you, this was mostly Ethiopian Orthodox and Muslims in Montgomery County who were making these protests. And there's a definite animosity from the school board towards the parents' desires just to control when their children receive this kind of information. So we ended up bringing the lawsuit. A federal district judge in Maryland said, when you put your children in public school, you no longer have a say in what they are taught. And your only other options are to send them to private school or to homeschool, which for most of our parents was just not an option. Now, I do have to give the judge some credit. For 50 years, the Supreme Court in 1972 ruled in a case called Wisconsin versus Yoder, where the Amish wanted to withdraw their children from public high school, and the state wanted them to attend through 10th grade. And parents were actually being criminally fined and thrown in jail for keeping their children home from school. They took their case to the Supreme Court, and the Supreme Court said, yes, parents should have the right to direct the religious upbringing of their children. And if that means withdrawing their children from public schools, as long as their children are receiving what they need emotionally, psychologically to prepare to become productive citizens, even if within the framework of a Amish belief, then that was sufficient. But for 50 years afterwards, courts basically ignored that ruling and said it was unique to the Amish tradition because of the more restrictive beliefs and isolationist views or separatist views of the faith. And there's almost no decision in the courts following that was recognizing the right of parents to direct the religious upbringing of their children. One of the challenges when you go to the Supreme Court is you're trying to show that there's a split in the lower court cases, that the Supreme Court should step in because you get one ruling if you live in one state and another ruling if you live in a different state. And so when we were writing our petition to the court, trying to identify a split, we found one case, coming out of the Eighth Circuit, that we kind of had to, put a little extra spin on the.
I don't know what you're talking about.
On the one or two lines in the brief to say, like, this is really an issue. And so it was more, I think that the Supreme Court saw this as an incredibly important issue. It was, you are hearing, as you know, there are stories all over the country of parents being basically cut out of the education of their children. And so I think the court saw this as an opportunity to readdress what is the role of parents, even if they choose to put their kids in public school. Do they then lose the right to direct the education, the religious upbringing of their children, or are they still entitled to be involved, at least to the extent of being to opt their children out? And so we were thrilled that the Supreme Court ruled 6-3 in our favor. Discouraged that it's only 6-3. It seems like it should be a 9-0 issue that parents retain that final control, even if it's just meaning, especially when it just means you can opt out. We never asked the court to remove the books from the school, but rather just asked the parents to be able to withdraw their own children when subjects came up. The school's response was, we can't handle this administratively. We pointed out that there are hundreds of students who are on individualized education plans who are being taken in and out of mainstream courses all day long, English as a second language learners, and ultimately prevailed in persuading the court that this was perfectly doable by the school district. They had no real reason to override the parents' religious upbringing. And so I do think Mahmoud will stand for decades, hopefully centuries, as a hallmark decision upholding the right of parents to control the religious upbringing of their children.
Thank you, Eric. Helen?
Great. Okay. Hello. So I teach both family law and the law and religion seminar at Scalia Law. So this is absolutely my sweet spot and the thing I'm most obsessed with at the moment. And I'm just delighted to be here to listen as well, including to the next panel. My contribution is to help you understand what Mahmoud did by distinguishing it from what went before. Eric referred to really having trouble finding federal courts that did differently. And I think the distinction should deepen your understanding of the case. Then I'm going to identify some of the questions that Mahmoud left outstanding. So pre-Mahmoud, you may know this already, states allowed families to opt out of the sex ed course, per se. And they described it different ways, but basically states did. But they didn't provide similar options for material that was the same stuff, but presented in places like English, reading, history. And when parents demanded the right as a constitutional matter, whether under First Amendment free exercise or under 14th Amendment substantive due process, parents' rights to direct their children's education under the 1920s cases of Pierce and Meyer, they were rebuffed. And I'll just give you what the schools were doing and what the court's rationales for denying parents' rights were in these cases. A Colorado school district denied parents of K through 5 kids opt-outs for videos and classroom discussions involving these videos where cute little teddy bears lamented that people sometimes refused to agree with other people's designation of their own sex. And it referred to those people as mean and, quote, someday we'll know better, unquote. A Massachusetts school, and you've probably heard of this case, kind of infamous, refused to notify parents about a school-wide assembly run by this company that does this for a living called Hot, Sexy, and Safer. On stage to this assembly, students were told that they were going to have a group sexual experience with audience participation. They were told to mimic masturbation on stage. They endorsed homosexuality, out-of-wedlock sex. They had a male minor lick an oversized condom along with the presenter, after which a female was called up to put it over his head and blow it up. And there was much more. And the court held that this was no problem and parents did not have any constitutional rights. There were also several cases involving books read to young children, as you can imagine, celebrating same-sex marriage or same-sex relationships. And one court would say, oh, it's just a couple of books. If this was a lot, it would be a problem. And then the next court would say, yeah, there were a lot of books and they were designed to influence, but that's not really a problem. You couldn't pierce these rationales. What were their rationales, the grounds on which the parents lost? There were about 6. The first is that exposing kids to this stuff is the internal affairs of the government, kind of like designating a social security number for a person or the government controlling its own property, a la the Supreme Court's big cases in Ling and Bowen. So internal affairs. Second, that the evolution cases where they determined that parents didn't have the right, or that the state didn't have the right to tailor its curriculum to religious parents' desires to not have evolution taught. This is the Epperson case. That parents here were trying to tailor the curriculum to their own religious views, and this is a no. Third, that it would be impracticable in a pluralistic society to navigate the floodgates of objections that would come if parents had a say. Fourth, that schools were just exposing students to material with no coercion or punishments involved. So parents' religion or child rearing wasn't even burdened. They were basically not even stating a cause of action. I think my favorite was the First Circuit reading books on same-sex unions to kindergartners and saying they were just teaching them the law. Okay, number 5, that Yoder's robust protection for parents' rights was sui generis. As Eric had already indicated, that it only applied to communities that separated themselves from the rest of the society, such that public education's desire to integrate children into the larger society was not relevant, or it only applied to communities whose school itself, anything that was non-homeschooling, would threaten their whole way of life. And hey, the Amish were kind of sui generis in the court's views. 6, that even if parents could establish a burden, states' interest in promoting tolerance and health were overriding compelling interests. Okay? So I cannot even begin to tell you how satisfying it was that Mahmoud did not go after 1, not 2, not 3, not 4, not 5. It went after all 6 of these. Okay? And it did so convincingly. It answered every bit of mischief that had gone on in the lower federal courts. Regarding internal affairs, you could hear Justice Alito laughing when he said, really? The school district instead was engaged in, quote, direct coercive interactions between the state and its young residents, unquote. That's not internal, that's as external as it gets. Tailoring the curriculum? No, as Eric indicated. The way the court put it is, parents were not seeking to micromanage the curriculum, only to have an opt-out. Impracticability? No. Schools have managed for a long time opt-outs from particular courses or for individual education plans, for English emergent learners, for students with religious or other objections. The just exposure, not compulsion. The majority in Mahmoud says this is not the constitutional test. Yoder simply disallowed any state action substantially interfering with parents' religious development of their children. And exposure, if you could conclude after a fact-intensive inquiry that it was interfering, even subtly, or if it added up to a pressure to conform, could constitute such impermissible interference. The court added that even where coercion required, the county did it, okay? These were young children with teachers as role models. The school insisted that contested matters, for instance about gender, were settled, demonstrated hostility to religious views, and normatively instructed children both with the contents of the books and the teacher's prescribed responses. The inapplicability of Yoder? No, said the court. Yoder is a general principle. It is not sui generis regarding the Amish. It is rather applicable to any parent claim that a school is interfering with parents' rights to direct their children's upbringing. And finally, sufficient state interests. The first important thing the court did here is say that the state had to have a strict scrutiny rationale. It had to show compelling state interests exercised by means least restrictive. And this is because the court said that the Smith decision, sort of lowering the scrutiny of most laws, neutral and generally applicable, to just a rational relationship test, did not apply specifically to the Yoder circumstance, which was present here. The state interfering with parents' religious transmission. And so it said the state did not at all have strong, compelling state interests. And I'd like to go into this more later because they cited, for instance, the fact that teaching tolerance was a little bit of a joke when they had some tremendous intolerance for dissenting or religious views on these matters. But also the whole question that Justice Thomas raised about, really, are these kids undereducated and are going to be not fit for polite society if these books are not read to them? Is it really a compelling state interest? Are these books absolutely necessary? So finally, what are the questions left hanging? I'm not even going to ask where this leaves the hybrid rights cases stuff under Smith, of which Yoder was given as an example, because I don't think we're going to have a clue what this hybrid unicorn is, and then Smith will die and we'll never have to answer the question. Okay, but the three questions that I think were alive. One, what's the line between parents properly controlling their children's religious development and their disallowed micromanaging the curriculum? Two, what about non-religious objections to aspects of the state's education? And three, do parents have a fundamental substantive due process right out of the educational context under the 14th Amendment to oversee their children's rearing? Okay, what might that look like? So that's it for me, and I guess I turn it over to Elizabeth.
Okay. Well, first, I'd like to just start by thanking Will for including the Center for Law and the Human Person. We're delighted to co-sponsor this event, and I'm just really grateful to be here to sort of learn at the feet of my distinguished co-panelists. I want to zoom out from the context of the case, maybe picking up on the last couple of things that Helen said about the open questions, and reflect on what Mahmoud might mean for parental rights generally. I don't think it's entirely clear what the import of Mahmoud is for parental rights that aren't motivated by religious concerns or that arise in the non-educational context. So I'm just going to kind of explain why I think it's not clear. So part of the challenge is that Mahmoud relied so heavily on Yoder. That's part of its appeal, but that's, I think, also part of the challenge, and solely on Yoder as a First Amendment case. Admittedly, the hybrid thing is weird, but still, it did sort of bring in a kind of a foothold, right, for non-religious parents. So it's true that despite their origins in the discredited Lochner era, the fundamental rights that were articulated by those early 20th century cases, Meyer and Pierce, such as the right to marry, the right to establish a home, and the right to raise and educate your children, they remain good law, and not just good law, but canonical, right? They're cited without really comment as far as their fundamental nature. But until Mahmoud, whether that was meaningful in concrete cases was disputed. And as Helen recounted, for decades in the curriculum dispute cases, parental rights didn't win the day. Now, some have suggested that Mahmoud is a kind of reframing of Pierce as a religious liberty case. Of course, it couldn't be a religious liberty case back in the 1920s because the First Amendment hadn't yet been incorporated to the states. But some suggest Mahmoud is really a sort of reframing of Pierce as a religious liberty case. And the majority opinion, thought for a second that might be one of my children calling. This happens from time to time. The majority opinion of Mahmoud cites Pierce only once, and that's for the proposition that the Constitution protects a parent's decision to send his child to a private religious school. So it does seem to kind of have at least relying on Pierce for this narrow religious liberty principle. But I don't think that's entirely right. For one, Pierce also, the case involving Pierce versus Society of Sisters also involved a secular military school. So I don't think it can be recast simply as a free exercise case. And even though it is the case that the contemporary court seems more willing to re-engage the substantive due process doctrine, I think, save for Justice Thomas, that appetite is really limited to, how Dobbs put it, the critical moral question posed by abortion. So I think while the right case squarely addressing all of this in the non-religious context will surely be a kind of occasion for asking this question, where are parental rights protected in the Constitution, et cetera, it's hard for me to imagine this court or any court denying that such rights do enjoy constitutional protection. It's just that Mahmoud doesn't really help us say where. Another way in which I think it's challenging to predict what this might look like is the Mahmoud's court's reliance on Yoder. So it doesn't use. It might be welcome that it didn't look at Smith, but it doesn't use history and tradition, right, to ask whether historically parents have had this sort of control over their children's education. And it still utilizes the tiers of scrutiny. So it sidesteps Smith, and it relies directly and heavily on Yoder with the invocation of the special character of the burden. That is, and the special character in Yoder is one that substantially interferes with the children's religious development and that poses a real threat of undermining the beliefs and practices the parents wish to instill in their children. And I think that that language, even though it's cast in the frame of religious upbringing, substantial interference and threat of undermining supports the argument that there is something unique about the authority of the family, some sphere of authority that's necessary for parents to have in order to discharge their duties to their children. And when that is undermined, right, that alone constitutes an impermissible burden. I think one of the wonderful things about Mahmoud relying so heavily on Yoder is that it shows that impermissible burden doesn't just happen to Amish families, right? You don't have to be that distinctive in your practice. And so, any one of the very diverse families from Montgomery County, right, can have this special burden. But beyond that, it's not clear exactly, I think, what that burden looks like. So in Mahmoud, the court said, well, this is exactly like Yoder, right, and therefore we don't need to kind of ask further about it. I don't think it was exactly like Yoder. I mean, it's not as existential a threat, I think, to that Yoder was to the Amish community. It's certainly significant. But I do think the fact that there is some difference open things up a little bit. Okay, so I think the point here is I think there is some support for a sphere of authority approach to be found in Mahmoud. But it's true that Mahmoud's holding remains tethered to the religious claims. It didn't invoke Troxel or Parham. It only invoked Pierce in this limited way. So I think we are left wondering how a court might frame a response to parental objections that are not grounded in religious conviction or in the non-educational context. Justice Thomas's concurring opinion offers a little more support, I think, to non-religious parents. While joining the court's judgment, he wrote separately to emphasize the historical and traditional understandings of what constituted the state's interests at stake. And he, wrote, relying on Helen's amicus brief to some extent, to say that sex ed or related topics to very young children lack deep roots in American educational practice, and for that reason they encroach on the family's traditional primacy. And he cites the language of Yoder, which the majority didn't, that said it's an enduring American tradition of parents occupying the primary role in the upbringing of their children, a role that includes the inculcation of religious beliefs. So includes, but certainly encompasses much more, right? But then he tacks back to the free exercise dimension. So I think we still don't know where parental rights as such are located in the Constitution, what tests would be applied to resolve disputes about them, et cetera. One welcome development is, and this is aside from the case, and perhaps provides more protection to parents than the piecemeal protection I think that we would likely see from the court, is the fact that more than half of the states now have parents' bills of rights, declaring parental rights to be fundamental, requiring strict scrutiny for any imposition on them. Some are limited to the education context, some are more broad. So I think that it does give us some hope that these things might be resolved at the state level more favorably for parents. I have more, but I think I'm already over time, so I'll stop there.
Well, thank you. Before getting into particular questions, is there anything that you all heard that you might want to respond to or address?
I just wanted to agree with Elizabeth that, the court's not citing Troxel, which is this case where a mom is going against the father of her children's parents for custody. And the lower courts gave her no time at all. The Supreme Court says it vacillates between parents have fundamental rights to direct their children's care, custody, and control, and you just have to give substantial deference to parents. The court just didn't play with Troxel, and I'm in the same place as Elizabeth on that, is that I think we can find some things we could extrapolate from to hand it over to the litigators for the next case, but I don't think they were very clear on that.
I was going to add, yeah, historically, I mean, I think the court has struggled with it. You mentioned Yoder itself wraps this in, this long-established American tradition or Western tradition. Barnett, another case, whether children can be forced to say the Pledge of Allegiance in school, brought by Jehovah's Witnesses parents. And there the court, if you read the main opinion, you wouldn't know it was a religious claim at all. It sounds just kind of like it's wrapped in free speech. I think trying maybe to extend this right to parents of all faiths. And I think one of our hopes in the case was that most school districts won't put that much effort into distinguishing requests from religious and non-religious parents. Now I noticed that Montgomery County's new opt-out form does say if you have a religious objection, maybe a lot of people will suddenly define their deeply held beliefs as religious. But eventually there will be a parent who I think says, I'm not willing to say that this is religious because that wouldn't be honest from my own perspective. And I still want the opt-out right. And I do think it will be interesting to, when that question gets forced, to see how the current court seems very hesitant to kind of expand these substantive due process rights. But I do think it's going to be hard to back away from the idea that is planted throughout a lot of these cases, that this is really something more fundamental than just a religious right, that there are parents, that the role of family and parents is going to have to demand some respect.
Yeah, go ahead.
Well, I was just going to raise one other, I think, open question. In one of the footnotes, the court says that the age of the children is highly relevant in assessing whether, the effect of any particular instruction, whether it constitutes the burden. And I think that's really interesting. Should parental rights, whether they're cast as religious freedom, exercises of religious liberty or not, diminish, right, as the child grows older? And if so, what does that look like? And what's the test for that? And I find that really interesting.
In one of my practice moods, I did get asked, well, what about the 24-year-old kid who's still at the state college, and did his parents get to opt him out? Right. It probably does cut off at 18, but I think, obviously in the Amish, the concern was they were more concerned about their older children being exposed to the values in the public school, ideas of competition, careerism, and so forth. Whereas in this case, Mahmoud, it was more about the youth. So I do think age is going to be important, but it shouldn't be dispositive one way or the other.
But in Yoder, if I recall, the court specifically said we're not dealing here with a case where the child has a different view than the parent, right?
That would be different maybe if the child had a different objection, and I think that's open in all of these cases.
Right.
But
Lots
as far
of
as
teenagers have opposite views of their children, right? Should that diminish their parents' authority?
Yeah.
I want to pick up on one thing that Eric said about the speech, right? About whether, if you can't get this on substantive due process rights of parents or if you don't have a religious claim. There's two guys who I would recommend that you read. One is Philip Hamburger, who you probably know from his famous work on, the administrative state is unlawful stuff. But he's written this brilliant piece. It's a think piece on freedom of speech as what he thinks is sort of the train that should drive parents' educational freedom. The other is an article by a guy. He's just retired from, I think, Quinnipiac Law School. I put his article, UChicago 1996 Parentalist Manifesto, as a God's gift to humanity kind of law review article level. There aren't many. This one, and the Parentalist Manifesto has speech as one of its driving thoughts, and that maybe the non-religious parent could pursue that. So there's a lot in both articles about that.
So maybe a good question for all of you to tackle, given that the conversation moved rather quickly to how does Mahmoud interrelate to maybe non-religious parental authority, would be to present maybe the other side of the question about what would be balanced against that, or what is the kind of competing authority, and then how you all would grapple with it. And in the education context, that would be the authority of public schools to educate children. Presumably, the public schools have the delegated authority of the parents to engage in some kind of education. The children are at the school for a long period of time during the day, and teachers are formative and impressionable, and on some level, it would seem parents are okay with that. Certainly, also, if you were to do a more historical analysis of parental education decisions, you would find, and this is something that both Justices Alito and Gorsuch, and then also Justice Thomas have pointed out, historically, before the rise of public schools, there was total authority given to tutors of educations. I mean, the idea of in loco parentis, in lieu of the parents, means you're essentially operating as their agent, which could potentially give very broad authority. And it seems like there are a lot of open questions about how do we translate, if we should even try, those ideas historically to what we expect of public schools. Maybe religion, because it's clearly beyond the power of the state to direct, like provides a way to sidestep some of those questions in a way that's still principled. But if we're going to be directing, like if we're going to be raising these broader questions about the parental educational authority, it seems like we have to grapple with the authority of public schools. How do you all think about that?
I'll just start very quickly. I would say two things. One, I think this question of the applicability of in loco parentis is super interesting. Justices Alito and Thomas have a kind of back and forth in Mahanoy, a case involving whether a school can discipline a student for conduct outside of school. And also, I wrote down the case here, and I'm not sure I can say it. Olentanji?
Sounds right to me.
Okay.
That's how I would have
We're
done
going
it.
with it.
A recent Sixth Circuit case where Judges Thapar and Nalbandian also have a helpful concurrence on this topic. And basically, the bottom line, I think, here is that in loco parentis, this traditional idea that when parents send their children to school, that they are delegating part of their natural authority to the school to make decisions. I mean, it could include even corporal punishment, and not just curricular decisions, but that's very complicated by compulsory education, which did not exist at the time that the in loco parentis doctrine was developed. I think there's probably gray areas if we even accept that loco parentis still applies, but certainly things that are not educational in nature, like that border on medical, like transitioning your children, et cetera, that has to be outside of what parents have delegated. I mean, I can't even get my child to have an aspirin at school without my permission, right? Yeah. So the second thing I would say is that that if the state does have this interest, right, in forming a educated citizenry, I think this is where Justice Thomas's concurrence is really helpful with respect to history. Right, to say like, well, what really is necessary for my child to be a good citizen, right? Is it necessary that they learn these things that Helen recounted, were performed at this school presentation? Or is it really just that they learn to add and subtract and read and the Declaration and things like that? So.
I'm going to add, there's language in Pierce about what does the state need to do? Provide the kind of education plainly necessary for good citizenship, right? So number one. Number two, you have Justice Thomas's recounting of sex ed being something that recently emerged. And I would add to that, there's a book by a guy named Jeff Moran called Teaching Sex, which is it's really pretty well done. I relied on it a fair amount in the brief, which is the whole history of the 20th century sex ed machine. But it is a fairly recent thing. And I want to add, I know I keep referring to my own writing, but like this is the area that I've just done my whole life. I wrote an article called Beyond the Sex Ed Wars. And it just shows that all of this sex ed that they've been doing is basically useless, right? It hasn't reached any of its goals. While they've been teaching it, rates of out-of-wedlock pregnancy, STDs, et cetera, have just gone up and up and up. And the article is a look at all of them, a look at the government data, and there's just very few of them that have any effect beyond like a few weeks, if that. I think the other thing is, I think the mask is off regarding whether the state is ideologically, normatively instructing our children. The idea before that they were doing these noble things relating to education and self-sufficiency and the kind of things that the court acknowledged in Yoder was a compelling state interest. The idea that they're not intensely ideological about particular things, I think that, again, the mask is off. And so there's an awareness of that could impact current thinking about the allocation between parents and state. And then the last thing is, this Giles article that I referred to does this interesting law and econ analysis of who has the incentive to do a better job with children. Are teachers who have your children for a semester or a year, who may also have interests in their career, pleasing the local school board, their boss, if the local school board has ideological interests, are they really as interested in the welfare of children as the people who are rearing them, who have to deal with the consequences of a well or poorly educated child, of a child who will or will not do sort of risky, problematic things in the sex, marriage, parenting arena? Are these people really to be trusted? There was an article in the Denver newspaper reacting to the little teddy bear telling people they were mean and parents not being able to opt out, where they had a kindergarten teacher excitedly telling the newspaper reporter 12 out of 20 of the kindergartners in her class said they were gay or trans, and she thought this was so exciting that they could come out to her. And it's like, are these really the people with the brains and the goals and the desire for your child to be healthy and happy? Or does the law and economics of the situation regarding benefits and incentives really lean toward the parents? There's so many ways you could knock at this.
I'm really glad you brought that up. It was actually one of your articles where I first really thought about this idea of who has the long-term, these questions about marriage, sexuality, and gender, regardless of which way you come out on them, you have to admit that they have immense consequences, not only for the individual, but for their family. And this idea that parents who are raising these children for at least 18 years usually, and then are going to live with the consequences of their decisions forever, that they don't have the same kind of incentive as a public school teacher or the school board, is just, to me, is ludicrous. This idea of, have we delegated this? It's kind of like saying, well, I voted for President Trump, therefore I've delegated everything I want to happen in my personal life to him. We vote for a school board for certain reasons, but we're not saying that we want them to control the lives of our children. I think, ultimately the Bill of Rights is the ultimate anti-delegation doctrine, right? Where we're saying, like, there are certain things that we never delegate, right? The rights remain with the individual to make certain decisions. And this question about where this falls within the Bill of Rights, but I think in principle we know that there is a right in there somewhere that is really not a delegable right. That parents are never, you can never assume at least that the parents have delegated all of this responsibility to the public schools. And one of the shortcomings of the religious claims is that the remedy is really an opt-out remedy, right? There is some truth to the fact that when you're voting for people to run the school system, there is some, you are letting them choose what curriculum is going to be used in the classroom. And so your opt-out or your remedy of your First Amendment violation is the right to opt out, at least under the free speech clause. I do think that Philip Hamburger's theory is a much broader, would give a much broader remedy. This idea that you're basically compelled to put your children in the public schools. That is subjecting them essentially to compelled speech. They have to kind of take in whatever the state decides to feed them. And if that's really a violation of the free speech clause, then the remedy is not just to opt them out, but to provide an equal education. You'd have to opt yourselves out of the whole school day. Therefore, the state has an obligation to pay for you to be educated somewhere else. And I think it's actually a very fascinating theory. I mean, a lot of people are asking right after Mahmoud came out, like, what does this do for the school choice movement? Mm-hmm. And my answer was typically like, I don't think it does that much, unfortunately, if that's what you really wanted out of it, because this is literally like, we didn't contest what the curriculum was. It was just, can we remove our kids from the classroom for that period of instruction? But I do think that's going to be an interesting question, is if you really kind of understand and are really appreciating the parental right to control the education of their children, is there a broader remedy under some aspect of the Bill of Rights or other constitutional provisions that would allow parents even greater control over the full education of their children?
You all kind of touched on this in answering the question, and also in your opening, that we're not really talking about a right per se, in the sense that we are really talking about another entity in our political community that has its own authority over certain matters. And Eric and I talked frequently about how much we enjoyed Wisconsin versus Yoder. And one of the things, at least to me, that's enjoyable about it is that, unlike many other Supreme Court opinions in the First Amendment area, it's not really written in individualistic language. There's a lot of language about handing on a distinct way of life and a particular tradition and resisting the hydraulic insistence, the court says, to conform to the values of the day. And I'm wondering about how you think constitutional law and policy can, if we're going to be protecting a different kind of sphere for parents, then we're going to need to continue to develop a more maybe communal respect for the role of religious institutions and parents and families in directing religious duties in our constitutional vocabulary. And I'm wondering how you all think Mahmoud can help with that.
I'll throw something out just to start, I guess. One is just, I mean, it's an amazing experience to watch, 3 families who have never considered bringing a lawsuit in their lives. They're very concerned about this. You talk to them, they start to entertain the idea. Taking them through this whole process of going to a federal court where they actually go and listen to the oral argument, which they've never done before. They hear a judge say something like, once you put your kids in public school, you have no further right in what they're taught. And then the day we're at the Supreme Court to see them saying like, wow, like I took this little action and my case is now going to be heard in the Supreme Court of the United States and I get to be there to hear it. And in that process, watching them, they were suddenly felt more empowered to become involved in the political process. Because we were telling them all along, like, look, we're not in a position to bring a lawsuit. We don't think the law would have room for it to get these books removed from the classroom. So they thought, well, okay, we're gonna. One of them got involved in one of the school board campaigns. They were all, it was just amazing to see kind of like their kind of rising awareness of that they could have impact as individual citizens and residents of Montgomery County. And I do think we have, maybe it's in a very prosperous society where we kind of have just, even institutions like churches and community groups, we've just shoved off so much of our social welfare, other good works to the government. And so I think many parents have just kind of forgotten, individuals have forgotten the good we can do as individuals, as small groups. I was just just a real quick aside, in Oklahoma at a charter board, the statewide charter school board was accepting applications for new charter schools. And just 2 women who had been teachers, one of them had kind of run a major VOTEC program for a public school. They came in with a proposal, they had a vision for how to have a better school, a better charter school. And they were heard. I think they're going to get their money. To me, it was just amazing to see, like, this is how America works. Everywhere you go, there are just individuals and small groups of people who have a vision, they go to work, and they try to make a difference. And I think I hope that Mahmoud will kind of revive some of that, kind of give more parents an idea that, hey, I should be involved, I can make a difference. And I think we just need more of that.
I would note, in the family law scholarship space, and Elizabeth can, I think, confirm this easily, the distrust of families. Like the articles are like, wow, the state wants to privatize parenting responsibilities. Like, wait, like, what is wrong with this sentence, right? The state wants to, like, as if they aren't in, say, private responsibilities, and then the state assists, right? In Catholic social teaching, we call this the principle of subsidiarity, right? You do at the smaller group level what you can do, and when that requires support from the larger community, you move there. But the angst and the distaste for, and the lack of trust for these small communities in family law scholarship is absolutely legion, okay? So among the powers that be in the academy and many in many state governments, this persists. I think a couple of historical circumstances. One, the rise of school choice and the success of charter schools and classical schools and other religious schools. The other, the visible, and I'm not slamming all public education. Like you, I had kids in Catholic school. I had one kid who went to Montgomery County High School for part of the time, and there were many, many really impressive things about what this high school could do. But overall, the idea that public education is this shining city on a hill, providing what's necessary for people to be, reading, writing, arithmetic, social skills, even they're independent adults. We know that that's not really panned out, especially for those with less privilege. And then we also see that we know, and I mean, AEI and Brookings had that joint report, Poverty, Opportunity, and Responsibility, that showed the good that an involved family could do, right? So we're at a historic moment where there should be some receptivity to this argument, but there's still a huge statist. And there was another case that blew my mind when, before Dobbs, the Supreme Court said, how could we give to parents in an abortion situation the right to oversee what their daughter is doing when the state doesn't have it? We don't have it. And so we can't allocate that right to parents. Like that flipped understanding that the state comes first and the family institution comes second is just, it's still prevalent in some courts, some legislatures. And to lift up the economic literature, the sociological literature, the anthropological, the psychological, the medical, as that Brookings AEI report did some of that, the Future of the Family reports that I think Princeton and Brookings do together. They're liberal on that, but they cite the right studies. We just need some more push on that sort of evidence, I think, to make the moment come to fruition.
Maybe the only thing I would add here is I'm so encouraged by the stories that you just shared about these individual parents and their efforts and what a difference they can make in local communities. And I don't think Mahmoud is the occasion for this as a legal matter or a constitutional matter, but I hope it encourages parents or in these environments to have the actual substantive conversations about the goods that are at stake, right? I mean, I'm always struck in listening to recounting of what happened in Mahmoud, where nearly in every case the plaintiffs or someone on behalf of the plaintiffs says something like what you said, which is we weren't asking them to change anything about what they were doing. We were just asking to opt out, right? Which obviously is super important. But yet, like maybe we should be asking them to change these things. They're bad. They're bad for children. And so I hope that this is the occasion for us to go beyond the kind of rights talk to the substantive goods at stake, right, on behalf of children and families.
All of your comments, I was thinking back to how Eric knows this well. Our opposing counsel in Mahmoud almost made an analogy to public educational authority in the way that you might think about the authority of an administrative agency, in the sense that he said something like, this is before the district court, look, once professional educators decide on the curriculum, that's effectively the end of the conversation in terms of parental rights, which is similar to the logic you hear in the context of administrative law, that, well, we have these delegated experts and they have all the right answers, and you and your like pesky little tradition ideas, that just doesn't show up on a graph, so why should we credit it? It's not maybe a surprise then that this logic of deference that we see in the administrative law context was the same, to me, kind of deference the public schools were getting when it came to curricular choices. But I think it's probably about time here that we open up to the audience for questions, both in person and online. Microphones will be distributed, and you can raise your hand, I'll call on you, a microphone will be handed to you. Please identify who you are, and then please have your question end with a question mark. Yes, right here, right in the front.
Hi, my name is Jennifer McCarr. I'm from the National School Boards Coalition, and I'm from New Jersey. So my question is more about comprehensive sex education. I know the Mahmoud versus Taylor case is specifically about books, and I think they're just about opting out. But what about, say, like a math curriculum or your English class that has these material sort of woven into them? Is there anything that we can do about maybe sort of eliminating that stuff?
I'll just say, going into Mahmoud, I was thinking about that kind of question. What if it's integrated all throughout? If the opt-out is your remedy, it's like, then you really are kind of stuck homeschooling or sending your kids to private school. And that was kind of the attitude I went into the case with. I love that Justice Thomas actually, in his concurring opinion, says schools can't get around this obligation by just weaving this material so thoroughly throughout. So Heath has thrown out a warning shot that if the school creates the problem by trying to put it everywhere so that opt-outs are impossible, then there may be a remedy. So I think that I would actually love to see, that's one of the, it may take a few steps to get there, but I would love to see some cases that kind of focus on that issue. But otherwise, I do think there is, just this issue of, how do you change the democratic process? I said some encouraging stories. One of the discouraging stories is I'm still surprised how many people I know personally who know me, go to church with me, and they're like, oh, what was that case about? Oh, what kind of books are they doing in Montgomery County? It's like, and unfortunately, our public school system right now is so, not through their own fault, but just because of the economic situation, history, parents depend so much on public schools to have a place for their kids to go. while they work to provide for their families. And I think COVID kind of alerted a lot of parents, like, wait, when they started seeing what their kids were being taught because they were doing on-screen classes, a lot more parents were like, wait, I better be more involved. But there's still a huge, segment of our population that they're just happy to have their kids be receiving an education, and they really don't have the time or the resources to track this carefully. And so I think that's just a bigger problem we have to be thinking about, is how do we engage more of our public to kind of be aware of what's happening in public schools.
I'm going to say something that ties together both what Eric and Elizabeth have said, which is, I think you can use, if we can't get a lawsuit saying it, you can take that language out of the majority opinion in Mahmoud, where a court said, if you're creating your own problem, the impracticability, how will I not expose kids to this by including it in all these other courses? That's your problem. The constitutional right stands. They have a right to opt out of this material. And it just, they said that's your own choice to create the impracticability problem. I would use that in a negotiation, sort of, nice, cheerful parents, threatening kind of way. The other thing is, with Elizabeth, in my review of every single major comprehensive sex ed program, the idea that these are really in the best interest of children or having any impact, really no. And so I'd like to begin going after them, not because, we're the anti-sex people or, the just say no is all there is. It's more because they are ideological and useless. Let alone, I think, eventually, if we can pull out of Mahmoud and other cases, like Elizabeth said toward the end of her presentation, things that are fundamentally important to the parents, things that are about their upbringing and their development, everything from what sex you are to how you relate to other people. These things are so central to who the adult person is that, that to me, even if it's not a religious objection, the parents could object to this kinds of material because it interferes with the development of the human person. I used to say in the Me Too movement, it wasn't about a boss running around the desk with the secretary saying, take my clothes to the dry cleaner. It was sexual. A sexual thinking about oneself, one's relationships, who you are, what you will do. It goes to the core of the person more than other things. It's about human development, psychological, medical, emotional, spiritual. And I'd like to go aim after those in a way that wasn't the old abstinence comprehensive fight or religion versus sex fight. It was more about the development of the human person.
This is a very tiny point after that beautiful big picture answer, but the court has signaled that it's not just about books, for example, and it just remanded a case, I think, to the Second Circuit, Miller versus McDonald, having to do with, again, religious objections to a school vaccination policy. So the court remanded it in light of Mahmoud. So I think there is at least some signaling, right, that this isn't just limited to books.
Although to your, I think Helen made this point about the circular logic in the pre-Mahmoud cases. Before Mahmoud and after Yoder, some courts would say, well, maybe it's possible that you could have a parental claim if you're talking about something that's not the curriculum, like something else that the school does that's not curricular. But when you're talking about curriculum, that's the core of what the school does. And now, at least under one Sixth Circuit decision, actually, apparently the rule is, look, if you're talking about the core of what the school does, of course the parents have a claim. But if you're talking about this peripheral stuff, you actually don't have a claim. So,
Yeah.
But yeah, fascinating how that works. Other questions from the audience out here? Well, I will prompt one that might prompt some more thinking, which is, it was mentioned briefly, Employment Division versus Smith was kind of set aside. In one sense, I mean, Employment Division versus Smith used to be the logic for deferring to public schools because your answer is the democratic process. And so is there something to the idea that Mahmoud actually is more of a rebuke of Smith than just not using hybrid rights? It actually rebuts, Eric, you nicely put it as the Bill of Rights is the ultimate non-delegation doctrine. Like, it kind of rebuts the whole idea that the schoolhouse doors can both be closed to you as parents and the courthouse doors can be closed at the same time. Is there more that, Mahmoud tells us about maybe the waning days of Smith?
I liked in the footnote, the court says, kind of has to address, that Smith characterized this as a hybrid rights situation. You have both parental rights and religious rights, or speech rights and religious rights. But the court, I can't remember the exact language that Alita uses there, but he says, the court assumed that the reason was basically hybrid rights, but suggesting, no, there is definitely a reason why this is different. The court assumed it was that. There's probably another explanation we don't have to get into today. But I do think he was definitely sidelining Smith in that way. But I think it certainly showed, Smith has some very significant limits. The court's already in a number of areas, church autonomy, parental rights, been saying Smith doesn't apply in all of these contexts. I do think it's a signal from the court that they don't like Smith and they'd like to back away from it. It may be, I think part of their philosophy is often just like limiting old cases they don't like to such a narrow sphere that they don't have much application. So I can see them trying to do that, but hopefully it's a signal that they will ultimately reverse it, because I do think it has done a lot of damage over its 30-plus year history.
Any questions from the audience? Yep, go ahead. Yes.
I was just curious if you could, I'm Katie Garvey. I work at Catholic University of America with Professor Kirk. I was wondering if you could enumerate a couple of other examples of non-religious objections that might be something that could be brought to the courts at a future date.
I think the big one we've seen so far has been the objection to the secret transition policies that a lot of school districts have, that if your child identifies as someone of the opposite sex, the school will help them transition, will facilitate with the use of pronouns or information, whatever it may be, without telling the parents, and telling teachers that they can't tell the parents and so forth. And those cases have mostly been brought under the substantive due process claim, under the substantive due process principle. And I think by, some have involved religious parents, but some by apparently not religious parents who haven't brought them as free exercise type challenges. So I think that's going to be one of the big areas that we see that coming up. I suppose there could be other substantive curricula that maybe non-religious parents bring claims for. I actually think that those are going to be harder cases because there just aren't going to be as many of them being brought, or parents will just kind of slip in as a religious objection. But I think the transgender issue is definitely a big one that's this court. I think the court is not going to be able to avoid. Ultimately, it's going to have to do something on that.
And on that one, I would add, it's watching people's argument and litigation techniques. All along in the transgender transition question, the argument from those who want a ready and quick transition, even of minors, is, you'd hear the doctor say to the parent, a boy says he's a girl, do you want a dead boy or a live girl, sort of thing. And now they're saying, oh, by the way, this isn't medical at all. So Elizabeth made reference to the parents' rights in Parham, which is a case about what was necessary before parents could place a child under the care of a mental institution. How much third-party evaluation do you have? And it was like a neutral medical fact finder, right, had to do it, but it didn't have to be an adversary hearing. This question of parents' authority over medical stuff is pretty confirmed, right? You have mature minor doctrines, you have parents making decisions that could cause, immediate drastic harm or death. But aside from those very drastic limits, parents' authority is pretty confirmed. But now in these secret transition cases, they literally are arguing this is not medical at all. In a case where a psychologist was saying this is a psychological emergency, now it's not medical at all, right? There's other things, and I was thinking of a case that was so tricky for, it still remains. It's a Sixth Circuit case, Mozart, the Mozart case, where parents didn't want the children taught about occult, feminism, certain things. They said these were violative of I think it was a fundamentalist Protestant tradition. And questions like that, I think that's where people who don't, I don't want you presenting history this way, or I don't want you talking about feminism that way. First of all, we don't see a flurry of cases in this. This is why I think they're difficult, and Mahmoud doesn't make them easy. I don't think you've seen a flurry of cases in that, but I do think there's some little clues in Mahmoud. youth being one of them. The other is there a subtle pressure to conform? The other thing is it something about sort of fundamental aspect of child rearing like religion is? The other is presenting only one side of a contested question. These are little notes in Mahmoud that I think if you put together, you can begin to make an argument about this. But I just don't think we're seeing hordes of parents say, I don't like, the direction of this history book goes against Protestant, Jewish, Catholic, whatever, teaching on this subject, as drastically as telling a child, this is not or is your sex, this is how you should think about sex, goes to the question of people's understanding of their bodies, their lives, who God is, how we're supposed to love one another, sort of fundamental questions.
And in a certain sense, maybe the gender transition cases provide the court an opportunity to get into some of the broader questions around parental authority and protected by the Constitution without getting into some of the difficult questions around public schools that we were talking about. Because the premise of these gender transition policies is that they are cutting the parents out of knowing what their children are doing at school and whatever other authority public schools may have, the idea that you can just totally, you think about like the standard principal-agent relationship. The agent doesn't get to decapitate the principal. That's not how that works. Any other questions from the audience? Or yes, in the back.
I'm Joseph Flynn from Napa Legal. Thank you for the excellent panel. You talked a bit about at the end about the parental exclusion cases and how substantive due process has failed in a few different circuits. I'd love to hear about if SDP continues to fail and be rejected, what alternatives are there in those types of cases?
Well, I think religion is an obvious alternative, and there's a petition right now before the court that has both SDP and free exercise. We've asked the court, hey, the religion clause question is super easy after Mahmoud. Why don't you go ahead and at least do that? And again, that would go a long way for a lot of parents. I think if once the policy is generally you can't deny religious parents the information, schools don't have a lot of incentive to try to fool their non-religious parents who maybe even more are politically aligned with them, perhaps, if kind of demographic indications hold. But it's a good question. Otherwise, I think the free exercise clause is a big one that will make a lot of the inroads. But I'm not sure after that where the courts will go.
And I mentioned this, people who would like to try speech, right? Are you, as the state, interfering with parental speech when you give opposing speech? And the question of the youth, of the children, the question of the subtle pressure to conform, the pressure of the quantity of instruction. The Supreme Court in Mahmoud was sort of dismissive of the argument that the county was making. It said, listen, the parents can contradict any of this at home. We're definitely going to tell your kids, and we're not going to be any notice and chance to opt out. But once your kids give you an accounting of what they're learning at school, first of all, go, what? You can say, oh, your teachers are totally wrong. And those of us who have raised children through to adulthood know what a silly statement that is by the county. So speech would be, cutting edge. It'd be something for someone to try to run through the courts. Like Elizabeth said earlier, even though there's these, discomfort all the way to Justice Thomas going, I don't like substantive due process. It's here. I think it's here to stay. And the test is getting more rigorous post-Dobbs, hopes it stays that way. But I don't think it's going to go away for us to use.
And I would just say, I agree with those alternate theories, and I think they're important to put forward because I think, again, sort of repeating what's already been said, but relying on religion alone either leaves out, right, the non-religious parents who have either just moral, philosophical, scientific objections to these various things, but also sort of gives them an incentive to lie about what their motivations are, right? You saw this a lot with the COVID vaccine, right? A lot of people trying to get religious exemptions from COVID mandates, casting them as religion in sort of the most capacious way possible, right? When really they had informed consent problems and other kinds of more secular objections. So I think it's important that we do alongside the religious liberty claims, continue to put forward these other ones.
If you join me in thanking the panel for just really an excellent discussion. Thank you very much. All right. Good afternoon again. For those of us who might be joining us from the first time online or in person, my name is William Haun. I'm a non-resident scholar here at the American Enterprise Institute. And we are having the second panel in our discussion about Mahmoud and the future of parental religious exercise, co-sponsored with the CUA Law Center for Law and the Human Person. Our first discussion focused upon the Supreme Court decision itself in Mahmoud, as well as its potential legal implications. And if you saw the discussion either online, presently or later, or in person, you probably realized that it moved rather quickly into a discussion of not only what came next, but the kinds of questions, the legal questions, the underlying questions of principle, philosophy, and culture that America is going to be grappling with in order to build out a protection for parental direction and education more broadly. And this is the kind of panel that is perfectly suited to get into those broader questions for our culture, for how America's principles protect the family and can guarantee it in relation to self-government going forward. So joining us up on the stage are Tim Carney, who is a senior fellow here at AEI. He works on civil society, the family, localism, religion in America, economic competition, and electoral politics, and rebuilding the family with all of his many children all at once at Virginia. He is concurrently also a senior columnist at the Washington Examiner. Professor Sarah Gustafson is an assistant professor of politics at the Catholic University of America, and her research focuses on Alexis de Tocqueville, 19th century political thought, and the Western political tradition more broadly. She received her PhD from Harvard. And Professor Melissa Moschella is professor of philosophy at Notre Dame. She's authored extensively on parental authority and its relationship to natural law, including in 2 different books, and filed a really helpful amicus brief in the Supreme Court in Mahmoud, and has really given, I think, a foundational account for legal authority in relation to the parents and the state. And so we're very grateful that she can come all the way from Indiana to share her deep insights with us today. So if you please extend a warm welcome to our panel, and we'll proceed with conversation. Yes.
Good afternoon, everyone. I'm going first. I'm very grateful to the conveners for having me participate in this very timely conversation, but that's also about perennial questions about balancing the different parts, the different interests of the political community. And that's broadly what I'll speak on. I'm a political theorist. I'm not a lawyer or a scholar of law. And so my framing will be somewhat broader and somewhat different. But hopefully helpful and interesting and help to set up my fellow panelists. The fact that someone like Justice Kennedy, just to demonstrate how a political theorist thinks about these things somewhat differently, Justice Kennedy famously said that liberty involves defining one's own definition of existence, something like this, right? That might not mean much for the decision, but it's something that political theorists love to chew on as a barometer, as a way of thinking about our political culture more broadly. So Aristotle argued that a political community is made up of those who have more than nothing and less than everything in common. Nothing in common, you have no community. Everything in common is both impossible and futile, for it turns the family and city into one another and thus destroys both. And a political community therefore has a kind of natural diversity to it, rich and young, old and young, rich and poor, male and female, different families, though the city must also be unified by a common good. And so that the way that the city becomes one is through legislation and through a public education with a view to the demands of citizenship. But education doesn't happen first in the city, it happens first in the household. And to paraphrase McIntyre, the modes of flourishing of families may differ widely according to the different families, but the family is part of the common. And the goods of family life are achieved as part of achieving the common goods of the community. And these are not rivalrous or competitive goods. So the family shares some things with the common, but not all things, and the community has a claim on the family and on citizens through the law and education. But the family has a claim on the common that it holds without having to abandon that which makes it a family. And that includes something like parental authority, which we've already begun to really dive into the weeds on. But Aristotle is an insufficient guide, I think, for some of our discussion today for a few important historical and theoretical reasons. So let's turn closer to our day. This year is the 250th anniversary of our Declaration of Independence, and I do not want to derail our panel with conversations about the nature of the founding, How liberal? What kind of liberal? Liberal at all? But in this context, especially, I think it's worth stating that the liberal political tradition, which is an important part of our tradition, but certainly not the whole of it, has to address the topic of education and the role of the family and the role of parents as personal authorities in a very special way. So broad and varied as the liberal political tradition is, I think we can say a few things about it. Liberal theories are premised on equality, liberty, and consent. The fundamental liberal question is how to bring about a legitimate political order that binds originally and naturally free and equal individuals. The answer is consent and sovereignty granted by individuals to the government they either authorize, create, or themselves are. And this is not Aristotle, for whom political and social order from the family to the polis is natural and hierarchical. This is also not Filmer, against whose patriarchal account of political legitimacy Locke argued. And this sits uneasily with the family's necessary character, its natural character, and the natural differences among family members, which can be modified by culture and technology only so much. So I'm going to draw here a little bit from a political theorist by the name of Rita Kaganzin, who has a wonderful book on just this question. The family's pre-political existence and its claims to naturalness are, from a certain point of view, self-evident and intuitive. My students understand it when I teach state of nature theory. They don't understand how there can be a state of nature without a family in it, right? So these claims are as or more self-evident than the claims to natural human equality that we find in the Declaration of Independence, or the claims that we are in the beginning all individuals. And so because the family appears to predate or supersede the authority of any particular government, it poses a special theoretical challenge to liberal theories. Liberal theories have to make sense of it, and as a result, you can learn a lot from a liberal theory by what it does with the family, how it addresses the family, the degree to which it tries to subordinate it, instrumentalize it, and respect its dignity and autonomy. So on the one hand, you have a Tocqueville, who I spend a lot of time with, who is rather more Aristotelian in many of his key points than liberal, and who greatly esteems the family and local communities. Or you have a Locke, who is far more accommodating than many other contract theorists to the place of the family in a free society. But even for a Locke, the justification of parental authority is not nature, it's education in the service of a child's future freedom. There is also, however, another attitude found in our thinkers like Hobbes and Rousseau, as well as 19th and 20th century liberals and progressives, in which parental rule, and we've already heard some of this today, parental rule is an obstacle to freedom, individuality, and citizenship. Rousseau famously said that men must be forced to be free, and that is in part by abandoning any partial associations, any loyalties beyond loyalty to the state and the general will. Hence a civil religion in Rousseau, hence Hobbes' Leviathan ruling over doctrine and ideas. And in Hobbes, who, by the way, had no great love of scholasticism, Thomism, or the English common law, the child learns to prefer rule by the impersonal, consent-based authority of the sovereign, whose impersonal character makes you feel your dependence on them less, to prefer that to the dependence on the personal, non-voluntary, and direct authority of a parent. And along this line of thought, you might be tempted to believe that only parents can use their authority to tyrannize, coerce, or bias a child, but never a public representative, let alone a public school teacher who's been trained to professionalism and expertise. So in this view, the individual is liberated from the rule of their parents, which is possibly tyrannical, through education and ultimately participation in the state as a citizen. So the family is at worst an obstacle to your liberty that must be subordinated, and whatever rights it possesses as grants or permissions. And at best, it sets the conditions for the child's education to learn what freedom requires to become a better citizen. And in each case, I think we need to be wary about the consequences of thinking strictly in terms of individual and state. Now, today, we can encounter arguments along the following lines in the Mahmoud case, but also, I think, in the academy and my discipline's response to the Yoder decision many decades ago. So something like, it is morally arbitrary who, whether the state or the parent, exerts coercive control over a child, so long as the child's interests are served. Parents share with the state a duty to educate a child, and in some areas the state just knows better. The family is insufficient or inadequate to educate a child and may teach the child things that make them worse citizens. Schools must teach about every subject considered salient to the duties of citizenship in order to guarantee consistent instruction. And public schools, despite being subject to democratic accountability, are a protected space for children away from the personal authority of their parents so they can be liberated to become their own person. And therefore, parents have limited right or authority to know or contest what their child learns, is exposed to, or what goes in their body, or what name they go by, right? And so on and so forth. And some of these arguments are stronger and some of them are weaker. And this is not the Aristotelian or the subsidiarity vision, right? But these arguments readily acknowledge something that Aristotle would also acknowledge, that education is inevitably formative, right? And this is why we argue about these kinds of topics. And so the law's categories is very interesting, revisiting the decision. The law's categories of coercion and exposure tend to obscure this kind of more basic fact of formation, right? Even non-coercive exposure can be formative. So how do we deal with that formative character of education? Well, and again, I'm approaching this as a political theorist, right? So we've heard some of the legal angles on this. We could take some topics out of public schools entirely. How do we determine what those should be? What is so important it must not be taught in a public school, and what is so important that it must be taught in a public school? Well, that depends on deep theological, metaphysical questions and what we conceive of as the duties of citizenship. Opt-outs. Opt-outs often function like privileges to be claimed or permissions to be granted, sometimes at great expense to parents, as we've seen, right? That doesn't exactly make it sound like a natural right or a liberty if you have to fight at great expense to get the permission. And opt-outs create their own challenges, not only on the level of efficiency and administratability, but because we are rational, social, arguing creatures who try to get at the truth of things by persuading one another. Another would be school choice, voucher programs, opt-outs writ large, and this is increasingly popular, and the earlier panel kind of gestured to this. It might diminish the formative effect of public education on some populations, but it doesn't necessarily change what the public schools teach, and if law is a teacher, it still matters what the public schools teach. Another would be neutrality, or just the facts in teaching a subject, but if education is formative, how neutral can it be? And as Mahmoud shows, and the arguments show, if you revisit the oral arguments, neutrality, or what neutrality consists in, may be difficult to agree upon. And if education aims at both formation and knowledge of the truth, neutrality may not always be an option. So to draw to a close, from the perspective of a political theorist, from an Aristotelian or natural law perspective, parental authority, if it's temporary, it's also natural. It's not merely a grant of positive law, though it can and should be codified, bolstered, upheld in positive law and jurisprudence, right, at multiple levels in various ways, right? And I think my fellow panelists will speak about that more. But you don't need to be a Hobbesian to recognize that parental rights and duties are not they're not absolute, and to recognize that the state has legitimate claims on the education of its citizens. And so something like the move to create many civic centers at universities across the country is a legitimate, important response to the fact that our schools have failed to teach fundamentals of American civics. And so I think I'll sum up, I'm going to skip a little bit for the sake of time, just to say that it's fair to say we don't live in the America of Tocqueville's day, or even of the Meyer and Pierce decisions. And so relationships among parents and cities and states and the federal government have changed dramatically, and I think continue to change. I went to school before Common Core. Students who went to school after Common Core have a different experience of the public school system than I did. I'm a public school kid myself. And so if parents increasingly have to request permissions or exemptions or opt out or leave institutions entirely in order to raise their kids well, that raises much bigger, broader questions about the content of our public schools, but way beyond that, the development of our political culture over time.
Thank you. Wilson?
Great. Well, thanks also to the organizers. I think this is, I unfortunately missed some of the last panel, but enjoyed the discussion that I heard, and I'm looking forward to our discussion today as well. Mahmoud raises broader philosophical and constitutional issues about the respective scope and limits of parents' educational authority and state educational authority. And Sarah's remarks kind of pointedly brought out, what some of these disputes are and what's at stake in them. So in my brief opening remarks, what I'd like to do is propose a standard for resolving these conflicts between parental authority and state authority that is philosophically grounded, but also, in my view, in line with our constitutional tradition. Properly understanding the scope and limits of state authority with respect to children requires having an accurate understanding of political authority itself in the first place. So what's the purpose of political authority? Well, it's not to usurp or replace the proper authority of the individuals, families, and other sub-political communities that make up political society. Rather, political authority's purpose is to remedy the insufficiencies of these individuals and groups by serving as a kind of overarching authority with coercive power to help coordinate society's members so that they can reliably and efficiently attain goods like order, security from internal and external threats, public goods, infrastructure, utilities, and the like, and an impartial administration of justice. These, I think, are the main elements of the political common good, which might be summed up as the conditions that facilitate the pursuit of flourishing by the individuals and groups that make up the broader political society. Now, what's crucial about this account of political authority, and also at the heart of what it means to have limited government, is that it recognizes the existence of various layers and spheres of authority within society, which the state has an obligation to respect. So there's not only the general authority of individual adults to govern their own lives, but also the authority of groups, especially families and religious communities, to govern their own internal affairs, relatively free from state intrusion, except when required by the political common good. For those committed to limited government, political authority is overarching, but it's not totalitarian. And the essence of totalitarianism, as Hannah Arendt explains in her seminal work on the subject, is the elimination of all the mediating authorities between the individual and the state. And primary among these mediating authorities is the family. The family, headed by parents, has natural pre-political authority to control its internal affairs, especially the raising of children. It would have that authority even if there were no government, and the existence of government doesn't eradicate that natural primordial authority that parents have over their children. And this is something that the common law tradition also recognizes. Although children are, of course, also under the authority of the state, parental and state authority over children are on different planes. Children are primarily and directly under the authority of their parents. But the state's authority over children is mediated through the authority of parents, through the family, just as, for instance, I am only under the supranational authority of a body like the United Nations through the mediation of the United States government. So it's a kind of layered view of authority that I'm proposing here. And this layered nature of authority within the political community and the primacy of the family's child-rearing authority suggests an analogy between the family's relationship to the state and the state's relationship to the international community. Most international theorists think that coercive intervention into the affairs of a sovereign state by the international community is only considered justifiable either to stop grave human rights abuses or to stop serious direct harm to the international order. Analogously, coercive intervention into the family's natural sphere of authority is justified only to stop genuine abuse or neglect, non-ideologically defined, or to prevent grave harm to the public order. For instance, if parents are training children to be criminals or terrorists. This view is also echoed in the common law tradition, with the prominent American jurist Joseph Story, for instance, indicating that the state shouldn't interfere with the natural authority of parents unless they are clearly proven guilty of, quote, gross ill treatment. And state courts throughout the 19th century employed this standard. The upshot is that any policy that makes it difficult or impossible for parents to fulfill their parental obligations in line with their consciences is a serious violation of parental rights and also often of religious freedom, given that many parents see their parenting authority as a sacred trust from God. Of course, these rights are not absolute, but because they're so fundamental, a high bar needs to be met before the government is justified in overriding them. I think that high bar is effectively captured by the legal strict scrutiny standard, which indicates that the government may only burden certain fundamental rights if it can prove that there is no less burdensome way to achieve a compelling state interest. For example, in Pierce versus Society of Sisters, the landmark parental rights case, the Supreme Court overturned an Oregon law requiring all children to attend the public schools, effectively putting private schools out of business. Now, Oregon's purported reasons for the law included the desire to ensure that all children receive an education that fosters their development into patriotic, law-abiding citizens. The Oregon District Court, whose decision was affirmed by the Supreme Court, rightly argued that although educating future citizens is certainly an important state interest, eliminating private schools and forcing all children to attend public schools is not necessary for this end. Although the legal doctrine of strict scrutiny didn't exist at the time, the reasoning in the decision is effectively applying that rigorous standard by placing the burden of proof on the state to show not merely that the law at issue was related to some legitimate interest, but that it was necessary for the state's important interest in educating future citizens, and thus that there was no less burdensome way to achieve that goal. So I think this case is a helpful illustration of the scope and limits of government authority with regard to children's education. On the one hand, as the Pierce Court explicitly notes, quote, no question is raised regarding a state's authority to enact compulsory education laws, the purpose of which are to ensure that, quote, studies plainly essential to good citizenship are taught, and to prevent the teaching of anything, quote, manifestly inimical to the public welfare. However, because, as Pierce says, the child is not the mere creature of the state, and parental educational authority is prior to that of the state should pursue these legitimate educational goals in ways that assist parents in fulfilling their educational duties without usurping parents' educational authority. Oregon's attempt to mandate public schooling went beyond the bounds of state authority because it undermined parental control over education and wasn't strictly necessary to achieve the state's interest in ensuring that all children have access to an education sufficient to enable them to be law-abiding, productive citizens as adults. Now, Mahmoud, I think, is also a good example of how parental authority limits state educational authority, although unfortunately the court passed up an opportunity to acknowledge the independent parental rights ground for its ruling, and so to clarify the true scope and strength of parental rights in education, instead merely giving a religious free exercise decision, which is good as far as it goes, but not good enough in my view. So to sum up, my argument is that because parents have natural and primary authority over their children, the state's authority over children should generally be exercised in an indirect, subsidiary way, that is, through the mediation of parents and in ways that assist parents in fulfilling their responsibility without usurping parental authority. The exceptions to this are of two types. One, the state may intervene to protect children's welfare when parents prove themselves unfit through genuine abuse or neglect. And two, the state may enact requirements for civic purposes, for instance, compulsory education laws, to ensure all children can receive at least a minimal level of education, enabling them to be law-abiding, productive citizens. But they're justified in enforcing such requirements against parental objections only when this is truly necessary for a compelling state interest. Thank you.
Thank you. I am, as Will mentioned, a father of 6, and I'm also a refugee from Montgomery County, Maryland. And one of the things we send our kids to Catholic school, but I engaged a lot with the county government, both as a journalist and as a parent during the COVID times. And one of the things that really struck me was that it was a shortcoming of some of the language legal scholars use and conservatives sometimes use, and that we've been wrestling around this whole time here, which is neutrality. As Sarah was saying, it's hard to hold on to this. So one conservative response when they see Montgomery County schools teaching Pride Puppy is, let's get that out of there, and just the schools should do reading, writing, and arithmetic, and leave it there. Leave the values up to the parents. This is an ahistoric and I think very faulty idea. You can't teach there's a very limited way you could teach children without values, without sensitive issues going in. You can't talk about biology without talking about sex and gender. You can't talk about American history without talking about slavery. And there are some conservative states where some of the effect of what the states are doing of trying to get apolitical means, well, does this mean we can't really talk about slavery? So those debates are going on because but the idea of an apolitical education is, I think, a myth. And some of the rules we try to apply here, the neutrality that we want to have on values just doesn't stand up. And an example is, one of the ways that the liberal media will characterize what the parents in Montgomery County object to is say, these parents don't want their children to know that trans people exist. This is just a statement of fact. Trans people exist. What it really means is that people who are biologically male actually really are women. That is what they think is a statement of fact. And we just disagree. There's no neutrality on that. We have to fight. We have to fight over that to some extent. And in Montgomery County, we lose on the political front. If you had a school board race just on the lines of like, should the schools teach that, the transgender ideology, probably transgender ideology would win. So that's what our sort of political fights are for to some extent. And as far as cases of grave abuse, in California, there's law that if you don't affirm your child's gender transition, you're basically an abusive parent. I think if you do, you're basically an abusive parent. We have to fight. It's political there. And it was very clear that the people in charge of Montgomery County, part of what motivates them is that they have that view, that Hobbesian view, that the job of the government is to liberate children from their parents. And they made it very clear. And I think it was Kavanaugh who pointed this out. He said, wait a second, you got rid of the opt-out because too many parents were taking it? And they got rid of the opt-out because they realized they were failing in what they thought was their mission, which was to take these Ethiopian immigrant kids, these Muslim kids, and these Christian kids, and tear them away from what the school board called the dogma. That was one of the school board officials said she felt really bad for this girl, Muslim girl, who testified before because she was just parroting the dogma that she had inherited. And so they couldn't allow the opt-out because of that, because they thought it was not just, it wasn't just an accident. Part of what they were trying to do was to liberate the children from the dogma of their parents. So it is really a culture war, and to some extent, what we need, a lot of the Bill of Rights, a lot of that was trying to say, how can we defuse these culture wars that are inevitable in a pluralistic country? We were pluralistic in 1776. Sorry, we aren't supposed to make this about the founding. But one of the big ways we do it is localism, is subsidiarity, is to say, well, you know what? We do have to, at times, say, I'm from Greenwich Village, New York. Like, our public schools, thankfully in the 1980s, didn't teach some of this stuff, but they're not going to be conservative curricula there. And so some of what you're going to have to do is the unsatisfying answer given by some of the liberals on the court is, well, you just have to win a school board election, or you just have to put your kids in private school. But we also need our courts to understand the proper anthropology here, and this is where conservatives need to make it clear that when we talk about neutrality and when we talk about individualism, there's got to be a limit to that. That we are not fundamentally, it's a term given to me by one of my economically liberal friends who, I think he's becoming a Christian now, but he was mocking some of his other liberal friends by saying they all see every person as a free-floating, atomized bundle of rights. And I thought that was a good description, frankly, of what I think is a predominant elite view of the human person in America today. And that's what we have to overcome, to understand that we are fundamentally familial and relational creatures. And once you start with, so again, I'm taking a side in an anthropological debate, but so are the people who argue, well, no, who are arguing this sort of hyper-individualistic brand of liberalism. And so one of the things I think we need to do as we talk about this is to be careful to not just say, the school district doesn't have the right to impose its values on our kids. Because it's going to. It's going to impose values. As a journalist, we talk about this all the time. Oh, just be objective. It's impossible to be objective. You can try to be fair. You have to be honest. But it's impossible for a good education to not impose values. And so then one of the things that a lot of post-liberals in America today sort of tap into is the acknowledgement that, guess what, these public schools, they're really religious schools. And so we just need to win and impose our religion through the government. I don't agree with that, but I do think we need to start from the fact that there's no such thing as a value-free education. And again, as a parent who raised 6 kids in Montgomery County and left, frankly, largely because of what the government was doing during COVID and some of these battles, and witnessing that when they reopened the massage parlors and the tattoo parlors, when at the same time they were trying to close the Catholic and Jewish schools. They weren't allowing outdoor church services at the same time that the county was organizing BLM protests. It's an actual antipathy towards religion because they are offering a competing religion. And it's a religion with a particular anthropology which we have to be really careful that we don't echo. Individualism, neutrality, pluralism, all of those things are baked into everything about our country, but we've gone too far in that direction. As we talk about these things, we have to constantly remind ourselves and speak in such a way that puts the family first, that understands that we are fundamentally familial and relational creatures, and that we're not just free-floating, atomized bundles of rights.
Well, thank you all. That was really, really interesting and a really good fodder for conversation. I'm wondering if there's anything in particular any of you would like to respond to the other panelists, anything you heard you want to raise first. Go ahead.
I could just say something quickly. I want to say that I agree with Tim's point that there's no neutral in education, and that any attempt to say, oh, the schools should be neutral, I mean, that's unrealistic and also undesirable, right? Mm-hmm. We want children to learn good values, or as Sarah said, to be formed through their education. But I think that especially in a kind of extremely polarized culture like we have today, that's all the more reason why I think the only full answer to this is going to be school choice. Mm-hmm. Because I don't think, although I do think that the state has legitimate authority to ensure that children receive an education sufficient to be kind of decent citizens, I think that's fairly minimal, kind of what they can coercively impose. So I don't think there's any reason in principle, on the contrary, why the state should be the default education provider. And that's what's happening when the public schools have a monopoly on public educational funding. So I think that gets the order backwards in terms of the way the authority structure should work. Instead, the authority structure should be parents are the primary directors of their children's education. The state has an interest in that, so it makes sense for them to provide funding. But it doesn't make sense for them to be the ones that totally control the educational narrative and the ideologies. So I think as long as schools are teaching what is sufficient for kind of basic citizenship, then that state money is better funneled through parental educational control. And that kind of gets us away from the cultural wars happening in the schools, because then, sure, if you want your kids to learn a certain ideology, you can send them to that school, but nobody's forced to do that.
Go ahead.
On the anthropology point, I think there's it's easier in a lot of respects to make the rights talk arguments, right? But I think sometimes we say it's easier because that's just what we're accustomed to, right? And so I'm a kind of a believer that our country has a lot of unwitting natural lawyers running around, and maybe I'm deceived about this, maybe I'm wrong about this, but I actually think there are large numbers of people who listen to something like Joe Rogan and go to the gym and know that they can do so many push-ups and there are biological differences between men and women, right? I don't think you need to have a scholastic training, right, to grapple with some of these principles and come to a reasoned conclusion about them, and then say, this has X implications for my daughter in a public school, or this has Y implications for my son on, a team or something like this. So I think to the degree that we're willing to speak in terms of human anthropology, there are going to be people who maybe don't share religious convictions with people who are Muslim or Catholic or Jewish or whatnot, but can identify on a very deep level with some of these sort of basic principles, and that we shouldn't overlook that if we're interested in building out coalitions of people who are interested in these questions, which is in part why the substantive due process versus free exercise arguments that were touched on in the first panel and that Melissa also touched on are so interesting, right? So I'll just mention that. And then I think also it's worth mentioning that again, this has to do with some of the history and the sociology of our school systems, right? But there's a sociology to who becomes a teacher, right? There's a sociology to who chooses to become a public school teacher. And I would argue that sociology has changed over time. And those are the kinds of things that if we're interested or asking questions about the degree to which a school can be neutral really matter.
And I'll just, on the school choice point, add on, Montgomery County and Loudoun County have the two most sort of infamous, notorious, famous public school systems in the country right now. Montgomery County school system is, I think, 160,000 students. It was 180,000 before they closed for a year for COVID. Loudoun, I think, is over 100,000. Fairfax is about 140. This is supposed to be modern and super efficient, right? And to some extent, they have fewer bureaucrats per student, and that's something I like. But these massive school districts, it's just more likely to get politicized. You have literally George Soros and then conservative millionaires funding these school board candidates going at each other because there's so much at stake. And B, it's just more likely that a majority can force its will on a minority that disagrees with it when it's a county of 1 million people. And so this is, again, a point for subsidiarity, whether it's smaller school districts, school choice, whatever it's going to be. You can turn down the temperature on the culture wars if you, the more that you use subsidiarity.
Well, particularly, as the state grows, because one of the kind of uncontemplated dynamics when we look at what some of the theorists have said about liberalism and then where the modern American state is that I think it's fair to claim, maybe Hobbes aside, that there was a contemplation of a much more limited kind of state relationship. But now when you have the state that's regulating everything from anti-smoking campaigns to gender bias to teaching you about the gender unicorn, I mean, we're in a different environment. But I wanted to get to this question about maybe the difference between theory and practice, because Sarah, particularly when you were talking, it strikes me that certainly fair to describe the family as pre-political. It is. It also strikes me that its justifications are pre-liberal, and so that maybe is maybe explaining some of the difficulty here, because we readily go to the language of neutrality, individualism, choice, voluntarism. None of these things map neatly onto why the family has the authority that it has, or how the family actually operates, and it might be pretty terrible if it did. On this, and then also with regard to the public schools, they raise an interesting dynamic too, because public schools didn't exist at the founding, and nothing like them existed at the founding. And when they come on the scene, immediately we start to see this conflict that you all have been talking about between, okay, we agree in the abstract that the public schools have the authority to form good citizens. In the late 19th century, forming a good citizen meant forming a good Protestant, right? In the mid 20th century, it meant forming a good anti-communist, right? And then later it meant, getting rid of the Amish because of their agrarian lifestyle, and this is a modern industrialized economy. And now it means knowing 850 genders exist. And so in a way, what the values that the court has been grappling with is running into this practical thing on the ground where when those values have been asserted abstractly, they've reached really terrible consequences in practice. I mean, the conflicts in the late 19th and early 20th century that lead to Pierce and Meyer around, like, making Catholics use the King James Version of the Bible in public school were really terrible and underscored the rise of totalitarianism. And so there was a kind of retreat from that. And you can see a similar story with the Jehovah's Witnesses and the compulsory flag salute in the 40s, where Gobitis, which is the case that forced the Jehovah's Witnesses children to salute the flag, gets reversed within 3 years. I mean, that's remarkable. And then Yoder, Helen went through so nicely all of these really ridiculous rationales that have come up in the lower courts between Yoder and Mahmoud to just basically give the same protection to everyone else that the Amish got in Yoder. And Mahmoud defeats all of them. So I'm wondering, it seems to me what we need to do here is we need to learn something from American practice that maybe isn't as abstractly liberal as some of our theories and come up with a vocabulary for it. And you all are practicing the living of the family and its relationship to a free society. What does our vocabulary need from our practice about accommodation, about respecting distinct spaces? What do we need to talk in a way that better credits the idea of the family as its own authority?
That's I think it's a great question, and sometimes I think as a journalist, it's sometimes my job to just say things that I know are not widely accepted, but that are true. And so the family is the parents are the primary educators of the children, and the school ought to be the chief partner. This is something that I didn't think about. I went to public school in New York, and it wasn't until I enrolled my kids in Catholic school and they looked us in the eye and they said, "You are the primary educators of these children," that it was instantly true and kind of revolutionary. And so to continually assert that, and I try to use the word accommodation all the time. Especially also with a conservative audience who might be a little wary of accommodations because, what are we doing? We're lowering standards. No, families, parents, children need accommodations, and that is part of the way we have sort of peace in a liberal society. So to establish that parents are the primary educators, to talk about families constantly, not just individuals, and to try to make accommodation be a good word. Those are three of the ways I try.
I kind of say on accommodation, that was one thing that was so remarkable for all of the horrors that were pointed out by Montgomery County and Mahmoud. If you did have these accommodations, the actual practice nationwide, including in Montgomery County until these books came into the curriculum, was widespread accommodation.
I think accommodation, it works. Where I'm hesitant or don't like the word, right, is because it assumes it's a permission, or it sounds too much like a permission or a grant, right, as opposed to a kind of meeting of the minds or that more partnership model. So I'm not sure what a better word would look like, because accommodation also has this connotation of welcoming, right, of lack of hostility, right, which may or may, accommodations may come with a bit of hostility, right, but at least the word suggests we're trying to be accommodating to you. But on the other hand, someone could say, well, if you're choosing to opt out of a particular class session, right, you have the standard class, and we are accommodating you by giving you a permission to leave. So why is that not an accurate description of what's happening, right? Because you do need a standard, right? You can't have a common education, right, if there's not a common standard. But where I get troubled by the vocabulary question, right, is because even a word like accommodation suggests too much that it's parents having to ask for something, right, that they may or may not be granted. And of course, whether or not they should be granted, that there are some accommodations, right, that might not be legitimate or that shouldn't be granted, right? But in this case, we're talking about accommodations that absolutely should be granted, right? So my hesitation is just to sum up on that accommodation should not be viewed as a kind of permission or grant from an all-powerful central authority that parents should be grateful for. And so to the degree we can steer it away from that, the better.
Yeah, I mean, I think even the word liberalism, I don't like it. And we keep coming back to the anniversary of the founding. But I mean, there's obviously certain ways in which our founding was liberal, but certain ways in which it was not. Certain ways it was much more deeply rooted in a classical understanding, in a Christian understanding. And the things that I think are good about our country that are typically associated with liberalism, things like the separation of powers, limited government, respect for basic civil liberties, things like that. Those are not, liberalism doesn't have a monopoly on those things. Those things had been justified by classical theorists. You can see justifications for those in medieval theories. You can see justifications for those in the natural law tradition, and justifications for those in those other traditions, are still being given. So I think, first of all, that it's important to kind of not equate limited government with liberalism, because those are two different things. And I think, even for the people who kind of want to throw liberalism away right now, it's partially because they want to throw the baby out with the bathwater. They want to say, oh, look, liberalism, it's tied up as a philosophy. Yeah, it's tied up with these problematic individualist, voluntarist notions. Okay, fine, I agree. But limited government can be justified on grounds that are not individualist, that are not voluntarist. And so I think we need a kind of different vocabulary to talk about that. And also, I think then we kind of need to push back, as Tim said, against the individualism and the voluntarism, and recognize that we are naturally social, we're naturally familial, and instead of talking so much about individual rights and things like that, we should talk about natural obligations that we have toward people. And I think that's a better way to talk about the issue of parental rights as well, is to say, well, this isn't just a kind of right that magically comes out of nowhere. This is because there's a natural obligation that parents have to care for their children, and then fulfilling that obligation requires the exercise of authority, and then that needs to be respected by the state.
That's right, and that's why, again, like the schools saying you parents are the primary educators is not just you have a permission to opt your kid out of something. You can't just offload it all onto us. Like, this is actually your job. The obligation and the right come together.
Well, and on that point, Pierce, it describes the liberty of parents as obligations. And it even says that, the reason why religious obligations are is because it calls them additional obligations. But the idea they transcend the state. But this gets to another question, because I think part of the challenge here is that while we live in a country that has strong comfort level with things like this, the separation of powers, certainly in a constitutional sense, or federalism, the idea that you might have something like that with the family or with religious bodies, for example, that there are certain things that they do that other people don't do, or certain authority that they have that just others don't, that maybe doesn't roll as naturally off the tongue. Your point about accommodation, the reason why that language is maybe so comfortable is because precisely for what you say, Sarah, that we act as if, and even when people, in an effort to praise the family, are talking about the little platoons or small groups, we act as if there's the government up here, there's the individual down here, there's this vague space here, and everything that happens is ultimately subsumed within the Hobbes superstructure. And maybe if that superstructure behaves badly to the people in here, maybe they get to do something else, but they don't have any independent authority. So do we need to build up maybe around the idea of obligations, that there are certain obligations that just aren't the state's? And how do we do that?
And I think that is an unnatural, Tocqueville said that will be an unnatural thought for democratic people because of our love of equality, then the demand to flatten everything and centralize everything. And so when I read that in Tocqueville, I just say, okay, so that means that there is a tension between liberalism and preserving power of little platoons and the power of the family. And so it requires constant work and constant labor and asserting it. And I think some of what Clarence Thomas has written in other ways, Gorsuch and hopefully in Mahmoud too, sort of reestablishing that, wait a second, this isn't the power of the state. And again, part of it is that we like democracy. And then one of the terms, a lot of times labor unions will be like, democratize the workplace, and then democratize the market. And suddenly you start to realize that democratize means majority absolute rule, which is like a nightmare, again, laid out by Tocqueville. And to say, no, you know what, your democracy doesn't get to reach into this place. And that my values are going to be, so that there's constant tension, and that we have to be comfortable with that tension, and the tension is actually good, like almost architecturally propping things up, and being weird. And as a Christian, like, be not conformed to this age, what St. Paul wrote. And so knowing that we're going to be in tension with the society and telling the society, I agree, you're telling me it's weird, I know my religion is weird. Like, we eat flesh and drink blood. Like, yes, we're weird, and you're going to learn to live with us. And so just embracing that tension between democracy and the very undemocratic structures within it.
I think another, I mean, it's easy to do as well. You know, we've been dunking a lot on public schools, right, for what they do poorly, right? But they also should not be expected to do everything, right? And so just as parents can assert authority by getting on school boards, parents and families have obligations to assert authority over multiple domains of their child's life, right? I saw an article online today about how, you know, this is not in the American case, this is in Great Britain, how many public school teachers in Great Britain are spending their hours, you know, tying children's nappies, right? Because children aren't potty trained by the time they get to school. Right? That's not the job of the public school teacher to train your child to be potty trained, right? You know, ideally, you know, you would hope that your child shows up to kindergarten having a basic sense of what the letters are, right? If not already reading. And so I do think, you know, again, and just for building on this with the Tocqueville point, right? Tocqueville is actually rather ambiguous about the status of the family once you get to soft despotism. There's a fantastic line, and this often goes unremarked on in the Tocqueville literature. I'm a Tocqueville person, so bear with me for a moment. People tend to focus on his analysis of women within the context of the family, but there's this wonderful line in his description of soft despotism where he says, if he still has a family, he no longer has a country. And that if is doing a lot of work, right? So there's a kind of ambivalence as to whether or not the family can endure under these intense conditions of individualism, materialism, and centralization, right? And so one way to actually help the public schools is for families to assert authority, not just in matters of curricula, but in manners, in sort of these other very basic areas of life that, properly speaking, a public school teacher should not have to be teaching your child.
Yeah, so maybe a benefit of shifting the language from, say, parental rights to parental obligations would have the benefit of not just simply shouting at the government, I have these obligations, get out of my way, but also maybe the community looking at the parents and going, you have these obligations, what are you doing? Well, maybe we should open it up to the audience at this point for questions. As before, a microphone will be handed out. I'll call on you. You can receive the microphone and announce who you are and have your question actually be a question. Yes, over here.
Thank you all for coming here. Sarah, I think you talked about common standard. My dad was in the service. I spent most of my education in the Northeast. And then he was transferred to Montgomery, Alabama, where I learned about the War of Northern Aggression. Surpassing my understanding of what I had learned in the Northeast. So I'm just wondering what your definition of common standard is.
Well, it's going to vary And this way it's going to vary is going to vary by subject, right? When I use that term, part of the difficulty or the conversations around opt-outs or accommodations, right, is if a child is not going to read this book, right, that we're intending to teach X, Y, Z, do we find them? Well, in the case of this, it was English language books, right, that taught, well, that were purported not to be teaching about gender and sexuality, but that had those themes included. What about a history book? Well, right. Yeah. Well, that would maybe a big question for our lawyers, right? But I think that kind of a question, I mean, it's a question of historical interpretation that's grounded in particular local views, right? I think there's a difference as to whether or not they're calling it the war of northern aggression versus factually misrepresenting what happens in a war, or what happens in a particular battle, something like this, right? So in the humanities, there is more leeway for interpretation, particularly as students get older, right? Now, if you're teaching about biology or mathematics, right, that standard is going to be somewhat different. And so I think part of the challenge, right, if you're a teacher in a classroom, right, and even college professors deal with this in a variety of ways. You will have students with accommodations, right, and you want to make sure that they get out of the classroom, basically what the other students are getting, right? So there needs to be a common syllabus, right? And when I talk to my students about this, I'm like, the syllabus is like the constitution for our classroom. It sets the basic framework by which we go about learning this common set of subject matter. And then there might have to be changes along the way. There might have to be adjustments made, right? Or accommodations for particular students, these sorts of things. So justice always involves having a general standard, but also recognizing exceptions, right? And that's the fundamental kind of Aristotelian question at the bottom of this whole conversation, right? Is how do you have a common standard, but also justly make exceptions to that standard?
But also you point out how sort of you have to get substantive and you have to take sides, and there's a limit of neutral rules. Like, this might be offensive to some parents. Yeah, if your parents, deeply believe that so I went to New York State public school, and the religion at the time was moral relativism, and they tried to teach that. But what we learned on the Civil War took a side that I think was right and had to take, that this was caused by the southern states wanting to preserve the institution of enslaving other human beings, and so they left the United States because they thought Lincoln was going to take that away from them. That's what I thought at the time. That's what I think today. I think teaching anything else is miseducating your children, but what abstract principle am I going to draw that's going to say, no, you can't have a different teaching on this, and yes, you can have it? I think it's really tough. And so this is why, if it's just about sexuality or just about values that you're allowing exceptions or doing, I don't think it's going to work. And that's why, to some extent, the political solution is going to have to be part of this, is that you're going to need school boards. You're going to need public attention, shaming people who are doing something idiotic, and that might be working on some of the left here. But at some point, no judges, no lawyers are going to come up with the perfect test of where you get accommodations, where everybody has to abide by the standard. And that's why the best thing, again, is devolving, decentralizing, giving parents more freedom. Will that be abused? Yes. But again, that tension is inevitably part of a pluralistic liberal society.
Yes, Haun.
Okay, now I can be really loud.
Good.
I find myself reluctant to give up on the idea of, not full-out neutrality, but fair representation of both sides. And this is the lawyer in me, undoubtedly, saying, so I'm teaching neuralgic material at a public university. whether I'm teaching Obergefell or Dobbs, whether I'm teaching Mahmoud or the Hobby Lobby or Little Sisters case, all difficult stuff. But the point of the academic exercise there is to express both sides' arguments in full, as strong as possible. So that makes sense in these cases. These are legal arguments. What are we talking about? Slavery and the Holocaust, where we're all going, there's a right answer, right? So I get that there are a variety and maybe a bunch of topics that do not admit of presentation. I can imagine a presentation that goes toward what you said about the War of Northern Aggression versus the way it would be characterized in the Northeast as a presentation of some call it this, some call it that. But at a certain point when you say there was slavery and then we got rid of it, we did it, you're going to get there. But I think there's a lot of topics on which we could have two sides in argumentation, and it's not just in law school.
No, and I would even agree on the Civil War to hash out like
What were the economic reasons that kept it alive in the South for so
and
long?
why were decent human beings defending the secession, defending Confederacy? What were their explanations for the war? I don't know that in 8th grade that would have been a worthwhile discussion, but as kids get older, a little bit of lawyerly training, not too much, but a little bit of lawyerly training is probably good. And where to draw that line, I don't want the Supreme Court drawing that line. I want it drawn 100,000 different ways in 100,000 different schools.
And there's an older article from Michael McConnell in the early 80s called Neutrality and the Religion Clauses. And if I'm remembering it correctly, he makes the point that when you're dealing with like moral formation in public schools, which is going to come up in different ways, that you have to understand neutrality essentially differently, in the sense that it is really about removing certain things, particularly religious obligations, from the role of, in this case, the public schools, because the only way you could actually keep a neutral space is to rightly allocate subject matters of like teaching and instruction and authority. And you could probably make a similar argument like that to other large government programs, in that if you really want to keep the public space neutral in some way, you need to rightly allocate who does what.
And I think also the age issue really matters here. And that was clearly at issue in Mahmoud as well, right? That you were talking about reading these controversial storybooks to pre-K or kindergarten students, which was part of what made it, I think, so egregious to many parents. And so I think there's an argument to be made for keeping these controversial things entirely out of the public schools at these very sensitive ages. There's no need for 5-year-olds to learn about this stuff, right? And then when they get a little bit older, teaching it in a kind of balanced way. So some people think this, some people think this. And so I think a lot of the objections that have been made on the gender issues, sexuality issues, other issues that are controversial is that one side is being taught as fact, as dogma. And not just that, but that students are being instructed that if they disagree with this or if they take issue with it, they are prejudiced, they are bigoted, they are wrong, right? They are immoral in some way. And so I think if public schools do, at older ages, want to teach about these more controversial things, then I do think the aspiration should be to do it in an even-handed way and say, well, there are different sides to this, and students are welcome to defend the side that they believe to be true. But that's very difficult. And that goes to the pipeline question as well that was discussed before in terms of, the way that teachers are educated or that public school professionals or education professionals are educated. The pipeline for that is quite ideological and quite progressive in its ideology. So I think that's another side of the issue is, who are the people who de facto end up having the authority in these situations, and how have they been educated, and how do we get different pipelines and different voices into these systems as well?
Yes.
I guess this question is probably mostly for Tim, but I'm curious of your reaction to what Eric shared about how, he's disappointed how many of his peers didn't really know what this case was about, or hadn't heard of it, or don't know of its import. And I just wonder, you're a journalist of the ordinary man, right? What does the ordinary person think about these issues? Are they like Sarah's gym bro who innately makes sense to them? Yeah.
The meta issues and the substantive issues. I think that unfortunately, average American doesn't love the idea of the patchwork of America that I love. That one school should teach one thing and another school teach another thing. I think that strikes the American mind as wrong. And again, I think that's what Tocqueville predicted. The idea that even two states would have different laws. People are like, that just makes no sense. Why are fireworks legal in Pennsylvania and illegal in Maryland? It should be the same everywhere. So that leveling impulse, I think, would be the main way in which the average guy I run into at a bar in Uniontown, Pennsylvania would disagree with me. Ironically, at the one bar in Uniontown I go to the most, Smitty's, is where I ran into a dad who told me, he's like, well, my daughter now identifies as a boy and I guess I have to accept it. But he never stopped calling her his daughter. So that, just immediate cognitive dissonance shows that the cultural trends, good and bad, trickle down from elites to the working class. That's always been the case in the US. And I wouldn't be surprised if you see Langley High School no longer having a bunch of transgendered students 5 years from now, but working class public schools full of them 5 years from now. But then B, he knew this child was his daughter. And so I think that there's both of those there, and that but on the other hand, I think that's sort of the Christian inheritance that we've been living off of for the last 60 years, a Christian understanding of the human being. I think that is disappearing and needs to be reasserted. So it's a net negative read by me on the society, on our culture, of whether the regular person agrees.
Mr. Baxter.
Yeah, a bit of a follow-up question. I'm just curious, as we talk about the family as a fundamental unit of society and having ultimate authority on these kinds of issues, but then if the family's kind of forgotten that, who revives that? And I'd just be interested in kind of what your thoughts are on, is it the role of the church? Is it the role of the state? In your ideal world, would it be a government leader who really embraced this vision and kind of renewed that vision? Or is there some other way of kind of reinstilling these values? I know it's a complicated question, but I'm just curious what your thoughts would be on that.
And I'm just going to add, in my worries, sort of inspired by my colleague here, Charles Murray, and Coming Apart, my worries about the working class in the U.S., I see, my wife and I joined a Facebook group called Large Family Tricks of the Trade. And some of it is here's the best place to buy a used Nissan Sprinter van. But most of it is completely dysfunctional family, or which rash is this? So, but for me, it's been this anthropological insight. And there's a lot of people who think, well, the minute my child turns 18 and or graduates high school, she's not my responsibility, which is this weird legalism replacing natural right. She's still your child. You still have these obligations and these duties. But just so I've seen that sort of trickling in there. But then I think, how do you restore it? When it comes to fathers abandoning their children and the mother of their children, in the U.S., we mostly focus on urban blacks, right? And there's been lots of campaigns to try to be actually, no, you have to step up and be a dad. I don't know if these work, but they're good and true. And a lot of it are nonprofits who are running it. Some of them are state and city governments that are doing it. So I would look into whether any of those work and then say, okay, this isn't just for deadbeat dads. This is for every parent, to remind them this is your primary obligation, is your family. And maybe none of them work, I don't know.
On that point, I have friends on both sides of the pronatalism public policy arguments in this town. And the way that I kind of fall on it is the best way is to have friends who have kids who let you hang out with their kids. You know, I have loved being Auntie Sarah to many of my friends' kids. But at the same time, you know, that doesn't produce rapid rates of change the way some people want to produce rapid rates of change to avoid a demographic cliff or something, right? But and so on the one hand, I tend to agree with my colleague and friend Catherine Pekalik that you can only do so much as a matter of policy and like pumping money into a situation to change a situation that's fundamentally about love and hope, right? But on the other hand, you can make, like, law is a teacher. Law is a teacher, and it does tell us things, and it does incentivize behavior. And so there are, I think, many meaningful fixes more on the policy side that we can make to encourage families to form where they might otherwise have a child but not actually form a family or something like this.
Yeah, and on the point of law being a teacher, I mean, I do think it's not a surprise that you see parents basically ceding their authority and responsibility to the state in terms of educating their children when the state has told them, yeah, well, once they go to school, the kids, you know, we educate them. And you stay out of it because you're just, you know, domestic terrorists if you try to impose your views on the school, right? So I do think a kind of statist mentality when it comes to education, at least formal education, actually ends up sending the wrong message, right? Sending the message that the state is the primary educator, which parents, you know, can listen to and say, okay, great, we don't have to worry too much about it then beyond that point. So I think if the messaging were to switch, and that would also be a switch in practice. I mean, I think this would also be one of the additional benefits of a kind of universal school choice idea is that messaging would also go along with, yeah, you parents, you're in the driver's seat here because it's your responsibility, so you better take it seriously, right? And I do think giving them that responsibility will help them to actually take it. There's an educational element there, and giving and empowering them such that they actually can exercise that authority will make them kind of more likely to kind of recognize that it's theirs and that it's an obligation, not just a right. But then, I mean, I think also, you know, Sarah's point about you learn this by watching other people is where, you know, the plight of the working classes is so troubling, right? Because the point there is that they're living in areas where the whole community doesn't have an intact family. Mm-hmm. And so who do they see? What model do they have, right? And so I do think, you know, there's no easy solution there. I mean, churches, you know, nonprofits, you know, associations at various levels have a role here. But I also think government can have a role even just in messaging, right? I mean, you could have a kind of the way the government had a messaging campaign against smoking. You could have a messaging campaign for the success sequence, you know, graduate from school, get a job, get married, and then have kids. And you could have messaging, I mean, you know, there was the recent Heritage paper proposing things like, you know, child tax credits that are dependent on marriage, right? That teaches, it also incentivizes. I mean, so there are small, as well as eliminating marriage penalties, right? So there's things that the government can do in terms of direct teaching, incentivizing, that can at least send the message that marriage is important and committing to, you know, the father or mother of your future children before having children with them is important, both for the sake of the children, also for your own happiness, and for the sake of the good of the larger community. I mean, that kind of messaging can actually help.
Can I add one further thing, just sort of continuing in this vein? Many of the folks in this town who are so concerned about the future of the family, the status of the family, falling birth rates or whatnot, there is such a temptation to think in terms of numbers because it's easier. So if you get them to marry young, they can have 5 kids, you know, before, you know, they turn 40, all these sorts of things, right? And while that's absolutely wonderful, and, you know, I want to encourage that, you know, we want people to form new families too, right? So if it's just a numbers game, right, adding that fifth child increases the joy of the family that already exists. But shouldn't we also want the unmarried, childless to form a family and have a child, right? Because if that happens, you've turned two people who are not parents into parents, right?
And that's good, and it's for the common good.
Yes,
And
yes,
and so
absolutely.
we're now budding. We're now.
And we have more people who are parents who are
Yes.
thinking about their responsibilities both to their children and to their broader community as a parent does.
And Tim Walz said his golden rule. He replaced Jesus' golden rule with his golden rule, which is mind your own business. And you're not minding your own business when you say it would be good for people to get married. But you're right. and same with like the schools. I remember during COVID, Montgomery County banned the parents from stepping foot in the public schools. And it was just a clear message. And it continued long after, long after they reopened, yada, yada. And it was, again, mind your own business. And one of the things when Tim Walz said mind your own business that he was talking about was how he banned book bans, which was his way of saying he passed a law that only librarians, certified librarians, were allowed to determine what books were in the school. Not even the principal, not the Board of Ed, not any parents. So mind your own business meant stop caring about your children's education. And so we're talking here about, no, we shouldn't mind our own business. We should care that people are getting married less and having fewer kids. We should care what they're teaching. Even us Catholic school parents should care what they're teaching this school, because the whole justification of public schools was this is for the common good. And so if the common good is being undermined by these schools, I'm saying, let, Tacoma Park be kind of crazy, but it's still bad if Tacoma Park is being kind of crazy.
Maybe just to bring it a little bit full circle at the end here, when talking about the shift in language, I mean, we've spent a lot of time in both panels talking about both the implications for Mahmoud outside the context of parental religious direction and how it would be good to kind of enrich parental authority outside the religious exercise context. But there's something also really positive about the idea that Mahmoud talks in rather strong terms about this enduring American tradition that recognizes that parental religious direction is special and burdening it doesn't require a showing of discrimination from the government first, that we could actually maybe build on that as like the start of, well, here's something that the state doesn't do. It doesn't direct your religious duties. And we're kind of counting on you parents to do that. And maybe that could be a basis for us to kind of motivate through the language of the law to teach in a way that allows parents to build in more strong ways. But thank you all so much for your time and attention this afternoon. That was a great discussion. Please give our panelists a round of applause.